Hello there, and welcome to another episode of the Advanced Resolution Management podcast and YouTube channel. We have a great panel this week, and we've got Jay Young and Kristine Kuzemka from the ARM panel. Welcome, both of you, and thank you for being here.
Thank you, Abbas.
So, before we really get into the crux of what today's session is really about, which is kind of, oriented towards, business ADR, in comparison to tort ADR. With the pandemic as it is, how is the ADR scene moving along? I mean, are you, the two of you doing more still remote ADR sessions, specifically mediations, I guess, and or arbitrations for that matter, or are you getting back into what, used to be the norm of in-person? So Jay, if you want to kick things off.
Sure. It's kind of a mix at this point. I've done some live in the last couple of weeks, those who are comfortable with it, of course, with the protocols for safety in place, but mostly still through Zoom or through Blue Jeans video. And remarkably, what I'm finding, and I don't know if this is the case with you, Kristine, but I'm finding that notwithstanding my desire to be in the same room with people, the settlement rate hasn't gone down, having some good success on video mediations.
What about you, Kristine?
Yes, I would echo what Jay said, and I would add that a lot of my parties find it more convenient to access the mediation through Blue Jeans, especially adjusters who are out of state. It seems to be logistically more feasible for them and more convenient for them to appear through a video chat. Yesterday I had a four-party mediation, and about halfway through, one of the participants says, "Oh, well, all I can see is you in this little square." And so, it just reminded me at the beginning to let folks know the logistic stuff. Hover over the thing that says gallery or speaker, and it's educating our clients as well through this.
Yeah. I think there's certain portions of this remote mediation and ADR generally that I think are gonna stay past the pandemic. I think there are some things that we've learned about ourselves and the industry that kind of educated both the neutrals and the potential clients, in the industry that I think are there to stay. I mean, have you found that as well?
Go ahead, Kristine.
Yes, absolutely. I think it is going to take us in a different direction. Certainly there's people who want to be in person, and as a mediator, I prefer that because I like to connect with people.
Of course.
And I've had, you can see in the video from here up. So you miss some body language, you miss cues, but with time, I've gotten better in working through those issues on Zoom or Blue Jeans, whatever the case may be. And I think if we're going to adapt to however the new normal is, we're certainly doing it in flying colors because we have great technology, and it's all about serving our clients. And
sure,
they dictate a lot of times what we're going to do, and so I'm flexible. Make it work.
Yeah, that's very, very interesting. And I mean, obviously, I think from a litigator's point of view, and I'm sure it's the same from a neutral standpoint, is that probably the biggest disadvantages of remote mediation and ADR generally is that you miss that human interpersonal aspect of things, right?
Yes, absolutely.
But is there anything else that you would flag as a major disadvantage apart from what I just pointed out?
I think viewing and sharing documents remotely can be difficult. It can be done, especially with the technology that we have, but it isn't as seamless as here's a piece of paper when you're in the same room with one another. But piggybacking on what Kristine said, I do miss that interpersonal interaction and the ability to connect with the litigants themselves in a way, that we normally would with small talk in a room. On the flip side, though, you sometimes gain information about them that you wouldn't. If they've got a cat that's coming and sitting on the back of their chair, it's an opportunity for us to, have that human element and connect there. What's your cat's name? How long have you had a cat? Those sorts of things, and build that relationship of trust in a different way,
Right.
a way that I would never have thought of.
That's actually really interesting. I never even thought about that. That's a very good observation because, you can learn a lot by the background. I mean, looking at Jay's office right now, there's actually quite a fair few clues about him that I actually didn't know. So that's actually a really good point, Jay. I didn't even think about that. That's really interesting. So let's move this along to why we've got you guys on here, because you both have an immense amount of experience about kind of a different type of mediation, because the panels that we've had on before have they do a wide array of mediations, obviously, but a large portion of their portfolio is tort mediations and ADR, whereas you guys tend to do a little bit more I guess consumer protection and business oriented, and specifically business is what I'm interested in for today. What, in your mind, if anything, distinguishes a business dispute mediation from a standardized fender-bender tort mediation, or even a catastrophic tort mediation? Like, are there things that you guys believe are distinctly different that makes that a different animal?
Yes. If I can go first, I would say that in a tort mediation, you're 9 times out of 10 dealing with an injured party, a plaintiff, who maybe this is their first exposure to any kind of litigation or their first mediation. And they may have been injured badly, right? So It's having empathy for them, educating them in a way that's not condescending or taking anything from their attorney, right? Reading the situation and building a rapport for them to trust you. In a business mediation, I'm generally working with sophisticated repeat players. So the way I build rapport there is I'm well prepared. I know the facts from both sides, or 3 sides or 4 sides, whatever, how many parties are in that business situation. And so I'm building my own credibility, that they know I've done my homework, that I'm prepared, I know the law, I understand it. I've gotten behind the scenes and talking with the parties before the mediation to find out what the color is and the backstory, so that I'm going in and working every angle I can to help them get to a resolution that day.
What about you, Jay?
I completely agree with Kristine. Some of the differences are that the factual backgrounds are often much more complicated, often involving years and years of relationships and correspondence and thousands of pages of emails. Whereas with a tort, you have a relationship that began with an accident that happened in seconds. And then the parties go on their way and have treatment or whatever. But, oftentimes in business litigation, litigators tend to think that they lack the emotional component in mediation, and they don't. The difference is that they still have a feeling of being victimized by someone else's wrongdoing. The difference is this is someone with whom they have a relationship. And so that emotional component may be under the surface because they're seasoned professionals or whatever, but typically they go into business relationships with people they trust already. Family members, other people in the business community, their peers, friends. And so when one of those people hurts you, it hurts very deeply. And so that emotional component is different in a commercial litigation, business litigation, than it is with a tort litigation, but it's still there. We may want to deny it, but it's still very much there. The difference is you have emotionally charged people with lots of money fighting other emotionally charged people with lots of money, and that adds color.
Well, I think you kind of, or like very nicely transitioned us to like my next topic, as one of the major differences is, even though in tort cases they're personal, but it's really about the victim and the injury that they may have suffered. It's not really personal between plaintiff and defendant, because majority of tort cases are negligence. You know, like they didn't mean to do it. They're not intentional. Whereas business disputes, from my rudimentary knowledge, I mean, unlike you guys, is I always perceive, especially, you know, partnership dissolutions and things like that, these are people with intimate relationships that, and which makes it more interesting because they tend to be more sophisticated, more money, and yet they tend to act more irrationally because it's so emotional.
Yeah. Yeah, it's more of a family dynamic sometimes than, you know, a divorce dynamic than you would find in a tort case.
Right. So
Absolutely.
I'm sorry, Kristine, what were you going to say?
Yeah, I had a four-party dispute, and it was partnership, and one person went out and joined somebody else, and it is like a divorce. And the one party who felt victimized and very much wronged was having a really hard time. And so you have to give them the latitude to have their emotions and understand and appreciate it, to be able to move things forward. And it's like a hybrid of real complicated facts. This is a matter that was going on for 5 years, and so there was some things that had to get out on the table before we could even really start the mediation. And it's giving the parties that room to do that. I totally agree with what Jay said.
So one of the other things, how does this change the dynamic of a business mediation, just like, you know, from a very broad brushstroke kind of perspective, which is most business disputes that I have seen, you don't usually get one plaintiff. There's almost always a counterclaim, because you don't just go, you breached the contract, and the other side says, no, I didn't, I've got good defenses. They're like, no, you breached first, so I'm going to counter you for breach. So they're both plaintiffs in a case. How does that change the dynamic in mediating that sort of litigation posture in comparison to a standardized plaintiff versus defendant?
You want to handle that first, Kristine?
Sure. Well, you're juggling balls, all right? You're basically litigating two cases. Yesterday with four parties, I had 3 settlement agreements, and they wanted a global. So I'm going from 3 different rooms, managing all the parties. And so there were claimants, there were counterclaimants. This was an appellate situation. So I was dealing with one winner and one loser, and that even complicates things further. And so it's keeping things straight. It's almost like being in the LSAT again with a logic problem. You know, I've got these 3 different players, keeping the claims and counterclaims straight. It's a challenge, and it's, oddly enough, it's a lot of fun. And especially when you get it done, and you know, that's a great feeling when you can put an end to 5 years of nasty litigation and people not liking each other, and sometimes the attorneys don't like each other. There's just a lot of bad blood, as it were, and so it's far more complicated than just the common tort plaintiff and insurance defense or tortfeasor in that situation.
Sure.
Yeah, typically by the time they come to mediation, there's an unspoken understanding that one party is the true plaintiff and is going to be getting a portion of the pie from the other party. Not always the case. And, you know, there are some cases where, you know, I may represent a party that has stronger claims in one area, and somebody represents somebody with stronger claims in another, and they may have competing claims and make settlements on those and have, you know, money going back and forth. But it's interesting that, you know, with the commercial litigation being driven by a broader array of controlling case law, controlling statutes, there's enough in there typically to suggest varying outcomes depending on your interpretation of those statutes or the interpretation of the case law, that allows both parties to stand up and convince themselves that they have a clear path to victory.
Right.
So that is a little bit more unique, and takes sometimes a little bit of a softer, strong hand than you otherwise would need.
Yeah, because I was thinking, like, you guys must have a lot more, like, have to have a lot more diplomacy, because you obviously don't want to alienate one of the parties from yourselves, and you have to kind of, like, I guess at least in some cases, as you just pointed out, be able to somehow communicate that one party is more the plaintiff than the other, meaning this party is the one that's going to be out of pocket, right? Like when you wash the two claims against each other. And I think that must take a certain amount of sophistication and maneuvering, because if you're coming out right out of the bat and going, hey, clearly you don't have a counterclaim, you can't do that, because you're going to have an upset party, so that, I think, must take some maneuvering. That must, would you say that's different than the way you would handle a tort case?
Jay?
Yeah, let me step in there. It is, I mean, typically you might have both parties making their initial offers of a demand against the other party. And so the trick there is finding your delta, find that middle point. So if your demand is $1 million and my demand is 500,000, we need to find a midpoint. And it typically is borne out in the first couple of rounds. You can kind of see where it might end up. But, you don't always have to say, you're not the true plaintiff here. You're going to end up paying in the beginning of the day. You can bear that out in the numbers that you might suggest to them as far as their moves are concerned.
I see. So one of the things that you guys mentioned, which I think find interesting, considering the context of remote mediations are concerned, I think we just discussed how business disputes can be very personal and people can get heated, I guess. Do you feel that the remote mediation forum diffuses that a little bit, because it's harder to get mad when you're not in the same room?
I guess it can, because, well, you're in virtual rooms when you're doing the remote mediation. And so I haven't run into that as much. Yesterday, I had one party that was really upset that he was going to have to pay a lot of money. And it's just giving them the space, picking up on that and saying, well, Mr. So-and-so, this looks like it's pretty hard for you today. And allowing him to say, yeah, I'm damn mad, and this shouldn't be happening, and they wronged me. And then making sure that person doesn't go down the rabbit hole for the next 10 minutes, right? So having built that trust and having their attorney there, we're working together to kind of bring things back to, stasis, as it were. Give them the room to vent, but then kind of get things back on track. It may be a little more difficult in a remote situation, but it can be done.
Sure. Jay?
Yeah, and it's a little bit artificial too, because even when they're in their virtual rooms and we leave and go into the opposing party's virtual room, they're in that virtual room with their counsel as another box on their computer screen or their smartphone or whatever. And so that artificial nature, I think, sometimes either gives people a little bit more pause to express their anger and their angst, or gives them freedom to do that, because they're in a home environment, maybe where they feel a little bit more comfortable dropping a few choice words. So, and you just have to navigate through it.
Yeah. We'll have a whole different program about those choice words, and we'll do a glossary.
Back to Jay and the animals that can appear on screen. Sometimes there can be kids, and I've had to watch myself. Like, okay, not to say damn or something because there's a 5-year-old there, right? So I've got to be careful too.
That's like so many different considerations. So do you, as neutrals, prepare differently for a business case in comparison to a tort case? Kristine?
Yes, I prepare to the nth degree for both, but it's different. In tort or product liability, you've got the common theme, the law is pretty static. In a business dispute, if it's a complex civil litigation matter that's a breach of contract, or it's a real estate matter, a lease agreement that's been breached, partnership dissolution, maybe a hybrid of a few things. I've got to make sure I understand the law. I've got the cases. I know the statutes, and I'm well versed in all the parties' claims that they're making in the law that they're relying on. So it's a little more complicated than a straight tort case. But in a tort case, I'm reading a lot of depositions. Maybe in a business case, I'm more focused on, as Jay said earlier, it's a lot of fact specific. There's a lot of documents, there's emails and things of that nature.
I agree. Understanding the scope of dispute is much more challenging with some business litigation, and sometimes the law is much more challenging. But I may not have to understand the anatomy of an injury or the biomechanics of an injury, but I still need to understand the people.
Yeah.
And so one way that it's the same is trying to connect with them and find out what is important to them, find out whether they feel like their voice has been heard, and if it hasn't been heard, giving them an opportunity in the mediation to be heard, and giving them a process where they can make decisions based on what it is that they need. And so conversations with counsel to understand their client and how they process information and make decisions is key in both types, but a little bit more so in, I think, in business litigation, because typically counsel are going to have a long-term relationship with large business clients, and they may understand and know this person, processes information in this way, and this is what they use to make determinations. And you can better communicate and better reach them if you do the following. That's key information. And you don't get that unless you pick up the phone and call counsel.
Of course. I mean, I think the pre-mediation call has to be very, probably even more important in a business case. Let me ask you a question, and I don't know the answer. I mean, it's not a rhetorical question by any stretch of imagination. It's genuine curiosity. So, if you have a catastrophic tort case, 9 out of 10 times the litigants know they're not going to win on a summary judgment, unless maybe a slip and fall example. Notwithstanding, something that you could bring an MSJ on, most things are going to be triable issues. The damages, if it's catastrophic, are kind of self-explanatory. And with some rudimentary, preliminary, voluntary exchange of information, it's possible to have that mediation much earlier in the procedural posture of a case, and get a result that's, serves justice, I guess. But would you say it's harder to do that with a business dispute? It generally needs to be further down the litigation track where some dispositive motions have been hashed out before they come to you? Or can you have that earlier resolution? And I guess obviously that's always going to be dependent upon the will of the parties. But how often do you see it earlier in the litigation track in comparison to, let's say, tort cases?
Who would you like to go first?
Let's go with you this time, Jay.
All right. I'm a big fan of early mediation for commercial litigation. The difficulty, Abbas, is when we discussed earlier that both parties think they have a clear path to victory. Yep. And sometimes I like to say, Mike Tyson once said that everybody has a game plan until they get punched in the mouth. And it's a lot the same in commercial litigation. Everybody thinks they've got a clear path to victory until somebody teaches them a lesson that they aren't standing on strong ground. And that doesn't happen until you have a few depositions and maybe some early dispositive motions, or at least partially dispositive motions. And so sometimes we can be successful if the parties are in a mindset to be open in early mediation. And other times it's clear that it wasn't a waste of time to do early mediation because we learned a lot about where we are, and a lot less expensively than if you had to go through discovery. And so you may be able to say, let's come back after we've done this finite amount of discovery, and we will know a little bit more about our strengths and weaknesses then. And then maybe we'll be in a position to actually, close this case and put it behind us.
Sure. Kristine?
Jay said it perfectly and concisely, and I can't add anything to it.
Fair
Absolutely.
enough. So let me ask you a more difficult question, because I'm sure you're going to get people that come to you and they know that you're mediators and you have a lot of experience. And the question is, why would I choose you over somebody else that may have been a judge, let's say? And because obviously, someone that's a neutral that wore the robe has that innate advantage that, they can go into a room and they say, hey, I've seen this tried out 100 times. Like, I can tell you what's going to happen. And that has to have some weight. But I mean, I, as a litigator, a lot of the times choose non-jurists or ex-jurists to mediate my cases. And I know why I do it. But I'm just curious to know why you think that's important sometimes based upon case selection.
I think it's important from a non-jurist perspective. As you said, a former jurist may come in and say, I've seen this 1,000 times. To me, that just shuts things down on a level right off the bat, okay? And it's a more directive style as opposed to a more facilitative style, which is mine. I'm there to help you get this resolved.
Right.
I know the law, I know the facts, and I'm not coming in and telling you that this is the way it's going to go. I do know some mediators, and sometimes it's effective. But I think the reason to go with someone who's a non-jurist, especially in these situations where it is complicated, and maybe it does look like a cookie cutter business dispute, but it's really not. And even if it is, I've given the parties the opportunity to say their piece. All right. At the end of the day, I find if all parties have been heard and they know you understand and they got to say what they needed, they may not really be happy about the end game, but they had their day with you. They sat in the driver's seat. They made the decision, and it wasn't by me going in there and telling them I know better. That seems a little condescending and a little arrogant. And like I said, sometimes it works, but that's just not my style.
Of course. Good answer. What about you, Jay?
As a litigator, I like to choose a mediator who understands people, understands the law, and who can effectively communicate risks and possible outcomes. And I try and be that as a mediator as well. And I think one of the things that may differentiate someone who is still practicing or recently practicing from a jurist who was last sat on the bench 10 years ago is that there may be a little bit more abreast of current trends and what juries are seeing and how they're reacting to things these days in this community. I think there's definitely the less facilitative approach that Kristine talked about. There's sometimes a muscle memory with former jurists because they spent years making decisions, right? And this is the way it's going to be. There's some room for that, right?
Sure.
I think every good mediator has to have the ability from time to time to be evaluative when asked or when it's appropriate.
Sure.
And sometimes litigants think they need a former jurist because they think they need that authority to tell the people in the other room that they're wrong. They don't want that authority to tell them that they're wrong, but they want the other room to know that they're wrong and lean on them. Kristine is a Supreme Court settlement judge and has been doing arbitrations for a long time. I have as well. Either one of us could stand in front of the litigants and say, I've been appointed in over 300 arbitrations and commercial litigation, ranging, up to $100 million. And perhaps that gains some of that authoritativeness that is necessary in order to, talk to them about what their likely outcome is. I don't think that's really necessary, though. I think, as long as you understand the law, as long as you understand the people, and you have those mediator skills, you can get past that. I've used former jurists, and I've used litigators, and I've used people who aren't even licensed to practice law, but are just very good at their mediator skills.
Yeah.
And to me, the skills of the mediator is more important than what they used to do in their job.
Sure. I mean, I told you I know why I sometimes choose non-jurists, and honestly, when it comes down to it, is obviously their personality that I think may be suited to that particular case, but the subject matter as well. I mean, even as officers of the court, one of our jobs is to educate the court, right? And they rely on your area of expertise to educate the court. And so, if you think a certain person has the knowledge in that certain area, I think that's just as good a reason to go to them rather than somebody else, because they really know when you're wrong or when you're right on that particular topic. And so that makes a lot of sense to me. I mean, this has been really fascinating, guys. Thank you. And I want to give you the last word on how, really your 2 or 3 do's and don'ts on what you expect in a brief from litigants when they're coming to you in a mediation. So we'll do the do's and then we'll do the don'ts, and we'll go in order. So Kristine, ladies first. What are your 2 or 3 do's?
Do be concise.
It's exactly that. Be brief.
Yeah. Cite the correct law. Include the prior negotiations between the parties, and tell me what you want.
Good. All right. That was nice and concise too. I love that. Jay.
Some things that people don't really think about is do share your brief with your client so that they understand what it is that you're doing that day. Too many times clients come in unaware of what's going to happen, and this is a strange environment for them. They've been told from the beginning they've got a good case, and now suddenly somebody's going to tell them that they have weaknesses. And if you haven't talked to them about that, it's high time, because I, as a mediator, shouldn't be the first time they're hearing that they have weaknesses in their case. So do talk about your strengths and weaknesses with your client. And this is one thing that, I get some pushback sometimes, but I suggest to counsel that they share their brief with opposing counsel. Now, not the confidential part, but that they treat their briefs more like a motion for summary judgment. Never, ever pass on a chance to show the strength of your position to the opposing party. And if you choose not to share your mediation brief with them, in my view, you're passing on an opportunity to educate them and their clients on the strength of your case. And that allows me as a mediator more flexibility, because I can say to their client, have you read their brief? When there's some pushback on an idea. And if they haven't, then I will give them the brief and say, I'd like you to read this section, and then I'm going to come back in and talk to you about it.
So I absolutely 100% agree with both of what you just said. But the last thing that you just said, Jay, I agree with it. But I run it like I have a little bit of issue doing that sometimes, because I'm also a great believer in sharing my weaknesses with the mediator in my brief. Because
but don't do that. Don't do that to opposing counsel.
No,
send a separate brief to the mediator.
You do 2 briefs.
Yeah.
Right. Because I feel like when you're willing to show your weaknesses, it's an opportunity to build some credibility with the mediator.
Right.
Absolutely. I can't tell you how many times as a Supreme Court settlement judge, somebody has lost and the jury was out 2 hours and found completely for the other side, and they've give me their brief and say, I have no weaknesses. Well, right? Your peer said that you did. But more importantly, it tells me that you as counsel are not prepared, and your client is not going to be prepared to be making decisions about their future, because you haven't had the tough conversation with them and talked about your weaknesses.
Good stuff. And finally, the don'ts. Kristine.
Don't give me your brief the day before the mediation.
That's good.
And don't recycle a motion for summary judgment.
Yes, I love that. Yeah.
I want a brief, and those are 2 big don'ts for me. Start fresh, and I would say on the last question about sharing the brief with opposing counsel, 2 briefs, because there's things they don't want them to know. I've been in mediations and I've asked, well, can I share this video that you have that totally eviscerates their case? No, we're going to use it at trial. Okay. And bound by confidentiality, right? So, yeah.
Jay?
Don't tell me that you have a slam dunk with no weaknesses. I think that's the most important thing. You know, all the suggestions that Kristine has made are great ones. If I can add one more, do give me a timeline, give me a chronology. It's easier for me to put the whole picture together when I can see the component parts. And you know, please feel free to summarize those 2,000 pages that you would otherwise give me as an attachment that I need to read in 2 hours.
Oh, man.
You need that long?
Just 2 hours, huh?
Yeah. Right.
That sounds like malpractice to me.
Yeah, right. Oh my goodness. Well, Kristine, Jay, it's been an absolute pleasure. I really appreciate you guys being here and sharing your thoughts and ideas and expertise. And I really hope that people get, you know, some useful tools and tips out of this, because I certainly did. And for the viewers out there, I know it's frustrating. Keep being safe. And ARM, we're here to welcome you, both in person, following the safety protocols, and of course remotely. And until next time, stay safe.